Hello, respected viewers. Welcome back to the English Law Channel. So now I'm going to be looking at certainty of term when it comes to leases. So what are the things to bear in mind now? So a lease has to start at some moment and it has to exist for a defined period of time. I'm trying to block out the light behind me, sorry. Anyway, Lace and Chandler 1944 is a case about that, where I said the lease is not for a year or 3 years or something usual like that, but as long as the Second World War lasts. And it was held that that was too uncertain because they didn't know how long it was going to last. Anyway, so if the maximum duration of the term is known beforehand, it doesn't matter that it could come to an end at the earlier date. They could choose to end it. Okay, service of notice to quit, something like that. There's such a thing called a periodic tenancy, and that's okay. That's got a definite term because either party can bring it to an end by giving the other party a certain amount of notice, a specified notice of 1 month or 3 months or whatever it is. However, if one party or other of them isn't able to do so, then the Lace and against Chandler rule is not fulfilled. Prudential Insurance Company Limited against London Residuary Body, 1992. Here, the House of Lords, which was then the Supreme Court, it reiterated the very strict principle that about certainty of term. Okay, you can see Array Midland Railway Company's Agreement, 1971. Ashburn, Anstalt, and Arnold, 1989, is a key case on this one. Because that's a case that tried to relax the rules. But anyway, the ruling here was important because there was a very strong expression of the rule, it must be upheld. The traditional rule, Lord Templeman, and actually he was the one who'd been in Midland Railway as the counsel for the losing side. So the House of Lords, who were not so sure about this, they questioned it, but they ultimately upheld it. So although they embraced this rule, they didn't seem to do so with much zeal. So the rule in Prudential is a bit different. The Supreme Court took this chance to avoid really the whole issue. If you look at Maxfield Housing Cooperative Limited against Beresford 2011, that went to the Supreme Court. This is a statutory provision which is seldom used. The case was about a clause in an occupancy agreement that said it could only be brought to an end if the occupier was in arrears or had somehow broke the terms of the agreement. So the Court of Appeal found that the agreement was a nullity for the lease because the term was uncertain. The maximum duration was not clear enough as per Prudential against LRB. So this was appealed to the Supreme Court, and the agreement was interpreted differently. Their exegesis was that it was permissible because the lease of uncertain duration was void because it didn't have a certain term. But prior to 1925, that the Law of Property Act there, a lease would have been deemed to be a tenancy for life, and it was determinable as in sort of finishable on a certain event, these things under the Law of Property Act 1925, section 149.6, they'll turn into a tenancy for 90 years and is determined as and brought to an end on the death of the tenant. It was Miss Beresford in that case, or otherwise in accordance with the agreement as either party stating they wish to withdraw it and giving the stipulated notice period. But you don't need to determine this issue. Lloyd Neuberger also voiced the belief that Miss Beresford would have won by a different reason if she hadn't invoked that line of reasoning, because the terms of the licence would be binding on the original parties to the licence. The Supreme Court, like the majority of the bench in Prudential against LRB, did not seem to be keen about this certainty of term requirement. Therefore, they found a rather circuitous route to avoid the implications based on the facts of the case. But you need to be cognizant of the restrictions on this decision. For instance, a device which means the lease of uncertain duration is regarded as a determinable life tenancy will not operate unless the lessee is a corporate entity, as they can't have a lease for life. Only a human being can have a lease for life, a natural person, not a legal person. So Maxfield is an important case on this. So the applicability of the rule here means that it converts to an uncertain term to a 90-year lease determinable on the person's life, as in when that comes to a close when the person dies. So that's called as the rule, and that is in consonance with the intention of the transacting parties. But Baroness Hale, who was present at the Supreme Court, she considered circumstances where the application of this rule would frustrate its intention. So Judge Hilliard had to face such a situation in Southern Housing Cooperative Limited against Walker, 2015. Here the landlord had given the tenants a weekly tenancy, but hadn't agreed to terminate the tenancy so long as the tenants abided by their agreement about the lease. There was a fetter, therefore, on the landlord's ability to terminate the lease, as in bring it to a close. There's a limitation. So that meant that the term was uncertain. Judge Hilliard had to decide whether the rule was applicable here or not. So this was his construction. Judge Hilliard decided the parties had seen the tenancy as a long-term thing, but they didn't intend to create a lease for the tenants' lifetimes. The provision which allowed the landlord to terminate in the event of a breach occurring was inconsistent with that intention. Therefore, so Judge Hilliard regarded the application of the rule to the case before him, and he said it would confound the accepted approach to the construction of an agreement, including tenancy agreement, substitute for the meaning of the contract on its true interpretation as an entirely different contract, thereby contradicting the intention of the parties. So Judge Hilliard was able to get around this strange result. So after closely scrutinising the judgments in Mexfield, he decided, with diffidence and anxieties, he said it, that the rule could be replaced, whereas application would be not in consonance with the intention of the contracting parties and would confound the core of their agreement. So one issue, which is still a moot point, is if the lease was void for uncertainty and wasn't saved by applying the rule, what therefore was the impact of the parties' agreement? So Judge Hilliard said obiter dicta, as in comments which are not part of his ratio decidendi, that in Mexfield the agreement which took effect as a contractual license, a license could only be determined in accordance with its terms. Southwood then is different from Mexfield on its factual basis, and moreover it addresses the importance of intention. Now this is an issue that the Supreme Court had shied away from tackling. So there's a contentious issue in Gilpin against Legg, 2017. Here Judge Paul Matthews took it another step, and he voiced the view, obiter dicta, that there was a respectful doubt on whether previous courts, previous cases that considered by the Supreme Court did in fact uphold that rule, which people sometimes seem to see is sacrosanct, that rule about certainty of term. So a term is normally supposed to take effect from the date of the grant, i.e. in possession, but sometimes you can create something limited to create something to create at a future date, a reversionary lease, but it cannot be more than 21 years after the date of grant. That's as per section 149.3 of the Law of Property Act 1925. For lease for life or until marriage would therefore not operate because of the rule in Lace and Chantler. Pretty unusual to have marriage as part of it, but sometimes that was the case. If it's granted at rent or in consideration of a fine, to take effect as a lease for 90 years. So the Law of Property Act 1925, section 146.9. So if there's no commencement date, that doesn't automatically mean that the lease doesn't count, especially if it's a commercial lease and the parties want it to be enforceable. Liverpool City Council against Walton Group plc 2002, that again being a case in point. Lastly, you must know that perpetual renewable leases are now regarded as leases of 2,000 years. We can't have eternity. 2,000 years is as close to eternity as the law will allow. Now the risk here is that a lease with a covenant for renewal on the same terms could be constructed as something which is perpetually renewable and then turned to a 2,000-year lease. For instance, there was Caerphilly Concrete Products Limited against Owen 1972 and Marjorie Burnett Limited against Barclay 1981. And there it was said that the leaning of the courts has been against perpetual renewals, so courts tend not to like them, a bit prejudiced against them. Okay, so that's enough on leases for the moment. Toodaloo.